Police have arrested a man who claims that he started the deadly fire at the Usindiso building in Marshalltown. This was in the Johannesburg CBD last August. 76 people were killed and scores displaced in the incident. Now, in his testimony at the inquiry into the disaster, the 29-year-old revealed shocking details of how he started the fire. He then says he had killed someone and wanted to hide the murder. The inquiry is probing the cause of that fire, and the evidence gathered, we're told, is inadmissible. So what does this mean? It simply means that it cannot be used against the witness in a court of law. So let's try and understand this, because this very person has now been arrested. Let's speak now to Advocate Deon Pool. He is a legal analyst joining us on the line. Advocate Pool, thank you very much for your time. So things moving very quickly in this case. What was evidence delivered under oath has now led to this person being put in a police holding cell. Was this always going to happen?
Well, the problem, good morning, sorry, first of all, the problem that you have is the evidence, as I understand it, would amount to a confession. But due to the fact that it may have been evidence under oath at the commission, but given the nature of the evidence, the prejudicial nature of the evidence, the fact that it does amount to a confession by this gentleman, he was now not warned accordingly as per the prescripts of the Criminal Procedure Act, and therefore that evidence cannot be tendered as evidence against him in a criminal case, unless he, of course, goes and repeats what he has told the Commission in a proper proceeding for a confession.
Yeah.
But also there, considering that he will have to admit to the elements of arson, he will have to admit to each and every single instance of a person that had been, that is deceased because of the fire that he set. And there you're working with the principle of dolus eventualis. So it's going to be somewhat difficult to manage him through that process unless, of course, he is legally represented.
Yeah.
But as far as the evidence is concerned, as it currently stands, that evidence is basically just what is on paper. It cannot be used against him, and at most it will have a evidentiary value that it gives an indication as to how the fire was started and why. But the state, in order to prosecute this gentleman, will have to have extrinsic evidence that connects him to the crime other than that which he has presented before the Commission.
This is a very interesting turn of events, Advocate Pool, and by that I'm going to say this, because this is part of what he has told the Commission, and that is that he was trying to hide the murder of a person he had strangled to death, and so he went and bought petrol, doused the body with petrol, and that is how the entire building was engulfed. But then the interesting elements to that is that he says he was under the influence of drugs. And so I'm giving all of this information so that you are able to tell us then, when you say, yes, what he has said in the Commission amounts to a confession, but he will have to repeat the exact same details in a court of law. However, intrinsic evidence is going to be needed. Explain that a little to us, that intrinsic evidence that is going to have to be linked to him for it to stand up in court.
It's more extrinsic evidence, in other words, evidence other than what he has presented. So something else that connects him to all of these various crimes. Either forensic evidence or an eyewitness seeing him go into the building with the can of petrol, or an eyewitness who can testify that he bought the can of petrol, and the time frame between him taking the petrol and lighting the fire is reasonable to suspect. But all of that circumstantial evidence, unless there is, of course, somebody that actually saw him set the fire or saw him put the body down or something to that effect. But his evidence, as it currently is on record before the Commission, is of no real value in a criminal prosecution because it amounts to a confession. Whether it's an admission or a confession, it's the same thing. You still have to warn that person. He still has the right to apply for legal representation. There are various rights that have to be explained to him, and he has to understand them. If you want to rely on the fact that it's a confession is basically a plea of guilty. In other words, in your confession that you make before a magistrate, in terms of the Criminal Procedure Act, you are admitting to every single element of the crime and admitting to knowing what you were doing was wrong, and you are in your full and sober senses at the time that you committed the offence. So those are all the aspects that need to go into a confession per se. An admission is less stringent because you can say that I did something, but I had, like in this instance, he was under the influence of drugs. Now, Section 1 of the Criminal Law Amendment Act is, and I'm under correction here, makes it the fact that you're under the influence of alcohol or drugs does not per se exclude your criminality. You can still be found guilty of the crime if the state proceeds to say, okay, fine, we accept that you were under the influence of alcohol or drugs at the time of the commission of this offence, but we are saying that you did that in order to gain the necessary guts to commit the offence or to do whatever you were doing. And therefore, we're going to ask the court to convict you anyway.
And so, Advocate Pool, as we taper down this conversation, the reportage around this, let me say news reports, specifically quoting Eyewitness News here, they are detailing that he broke down in tears and told the panel of commissioners that he often prayed that God would punish him as his actions led to one of South Africa's biggest tragedies. A part of why I'm giving this background is that the police, in arresting him overnight, have said in the statement that he is charged with arson, murder, that would be 76 counts because those are the people who lost their lives, including 120 counts of attempted murder. I suspect these are people who survived the fire but will live to tell the tale through their scars. How many years in jail is this person likely to sit for, if indeed that is where this is going?
Murder is a minimum sentence offence. Considering the amount of the amount of charges, each person who is deceased is a charge. Each person who has survived is a charge. So you will have the amount of murder charges. On top of that, the amount of attempted murder charges, and then, of course, the arson charge on top of that. I cannot see a court giving less than life imprisonment, but, of course, a person has to look at whether there are any mitigating circumstances. An aggravating circumstance would specifically be the fact that he did try and conceal one murder in this building by setting that area alight, and he ought to have known that by doing that he was going to jeopardize the lives of everybody else. That would be primarily that would be an aggravating factor, and then of course the attempted murder. So my view would be that a high court hearing this matter would have no qualms in handing down life imprisonment. You can't really get 10 life imprisonments. Life is life. But of course the person will have to look at the mitigating factors that in the event that there is a conviction that are presented by the accused.
Final question to you, and it relates to the work of the commission. And let's remind that commission is tasked with investigating the circumstances that led to what started that fire, and who should be, I suppose, held responsible for the general state of the building. Now that we know, or up until perhaps a person is convicted, i.e. this person who has confessed to this, how much of that commission's work is either cut in half or possibly nearly done?
The commission was appointed in order to investigate the causes of the fire and the reasons why so many people were injured and or killed as a consequence of this fire. At this present point in time, the commission knows how the fire was started and why. The commission still needs to make a finding as to how it came about that 77 people died as a consequence of this individual's actions. And that would be something related quite possibly to a duty that is intrinsically linked to the city and its management of these derelict buildings or evacuated buildings as we've come to know them over the years. My view would be is that if the city had secured the building properly and made sure that it was not able to be habitable by vagrants or migrants moving in there at will, there are news reports that there were shacks inside the building, which in itself is a fire hazard. Quite funnily enough, I think it was the day that the Kampepe Commission started sitting, or the day thereafter, the fire marshal arrived to come and say that there were too many people inside this venue and that they had to suspend the proceedings. If that had been the attitude most probably at the start, then I would have thought that it would have resulted in persons or families not moving into a building like that at will and be left to impunity, because had they not been there, I would know that there wouldn't have been so many injuries and deaths, and quite possibly the gentleman who went and set the fire would not have been able to get into the building in order to try and some subterfuge there as far as the body was concerned that he wanted to conceal.
Yeah. All right. Advocate Deon Pool, let me thank you very much for the information you have given us here, and quite interesting explanation indeed as to what happens next for this person who is understood to have made a confession now.